topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Orlando. Welcome to another Ask the Expert show where we bring you the top experts in the field of legal, health, financial, and home improvement. Hey, this is the last Thursday of the month. That means K. Bender Rimbaum, Community Association attorneys. Normally we have attorney Alan Swartzide. Today we are so lucky to have attorney Kirsten Hins. Good afternoon, attorney.
Hello, Steve.
Hey, listen, you're starting to get a fan club also, like Robert does. People really enjoy hearing from you. We got 4 or 5 letters right after your show just complimenting you on your knowledge and how you explain things. I just want you to know that the listeners and viewers really appreciate not only your knowledge, but how you explain to others. They really enjoy that.
I appreciate that. Thank you.
And we
try to, and this goes, with clients that we represent, when we give legal opinions, we try to keep it simple. They don't want citations to case law or, a treatise. So, which, it's taken a few years to learn how to not speak in legalese.
Understood. Hey, you know what I've kind of looked at it over the years. We have a lot of board members who all get together and listen to K. Bender Rimbaum shows. And I think that is just amazing.
That's awesome. I saw in some of the comments how board members, I guess, just gather to listen to the show. So that's fantastic. That's great.
So listen, we get new listeners every day. We're on 70 platforms. Tell people about K. Bender Rimbaum.
Sure. So K. Bender Rimbaum, for those who are not familiar with the firm, we are an exclusive community association law firm. So we represent exclusively condominium, homeowners, and then cooperative associations in the state of Florida. Our main office is located in South Florida in Pompano Beach, but we have been expanding over the years, and so now we have other locations. We have an office in Palm Beach Gardens. We have an office in the Orlando area, which is managed by my colleague Alan Schwartzite, who couldn't be here today, and then I manage the West Coast office for the firm, which is located in Tampa.
I tell you what's so incredible about K. Bender Rimbaum is education is so important to your firm. You and Alan and Michael are always out there doing all kinds of educational, whether it's in the South Florida area or Tampa or Orlando. You're out there educating, and there's so much going on that needs to be educated, but you're doing certification classes, which now are like 3 and 4 hours long, and it's just so wonderful to have a firm that is out there trying to help these associations.
Yeah, and I mean, we take a lot of time to prepare these courses. Obviously, laws change, and so we're constantly updating the course material to conform with current law and update, board members and managers and changes in the law. And all of these classes or webinars are free of charge. And we have a website calendar that any director or manager can just go on the website, check out our calendar for the next couple of months, select a class of interest, and just sign up.
Well, you can already see that questions are already formulating over in the chat line. We have got so many. Can you see those, Kirsten, in the comments?
Oh, let me see. Okay, gotcha. Yeah.
Why don't can we address? I think they're both okay. If a association is going through revitalization of covenant, what is the responsibility of the board?
Well, in terms of, I'm unclear as to whether the responsibility of the board, the question relates to responsibility of the board with the revitalization process or just ongoing responsibilities. I mean, the bottom line is that, the entity, the association, which is a not-for-profit corporation, it still exists, right? And it's operating. And so, you still have to operate the corporation, right? There's bills that need to be paid, and sort of certain other functions. So, I mean, that responsibility doesn't go away. Unfortunately, once the covenants are expired, you can't, the association can't really enforce the covenants against homeowners, such as, collect delinquent assessments. And so, then it becomes the responsibility of the board, a fiduciary obligation to revitalize those covenants.
Al has a follow-up. Can a board vote on expense items via email?
No, board members cannot vote via email. They can communicate via email, but really the formal vote needs to be taken either at a duly noticed board meeting or by written resolution in lieu of a meeting, so long as the resolution is signed by 100% of the directors.
Let's go to our next question in the chat. Is the violation committee meeting with a tenant and unit owner hearing an open meeting allowing everybody to intervene?
What was the question? Does it have to be open?
Yes. Committee meeting with a tenant and unit owner hearing an open meeting allowing everybody to intervene.
Well, if it is a condominium, then yes, committee meetings have to be treated like a board of directors meeting. So they have to be duly noticed with minutes taken, no different than a board meeting.
It's just so people know it's really important if you're going to write questions. We love your questions coming in on the chat line, but let us know if you're an HOA or a condo, because a lot of times there's a big difference in the two. So
Correct.
please let us know. Again, and also where we get most of our questions coming in, and literally we get 30 to 40 to sometimes 50 emails in a month for each show, uh, asking questions from you, which we love. You can send those to 954 336 3767. You can text those to us. Justin in Lake Mary wants to know, can an HOA board vote to change roof style and color without community vote? 1,000 homes that have the same terracotta color barrel tile roof and now allowing smooth black metal roofs. Would that be considered a material alteration since it pertains to the house Kristen, we get a lot of questions about roofs for HOAs.
Yes, and since the statute changed for 720 regarding hurricane protections and architectural changes, yeah, there's been confusion and amongst board members. But I think the listener posed this question particularly as to an HOA. So I'm going to presume that that's Chapter
Yes.
720 of the Florida statute. So the term material alteration really is a concept of condominiums, which refers to basically an exterior alteration to the common elements or association property. It's really not a concept in HOAs. But with that said, if we're talking about changes to the color and style of the roofs, I would suggest start with the declaration of covenants to confirm whether or not the board has the ability to approve or disapprove architectural changes to the exterior of the homes, such as roofs, right? Well, roofs is also, I think falls within the definition of hurricane protection, that the board has to adopt hurricane protection specifications. So really what the board should be doing is confirm authority in your governing documents that you have the ability to approve, disapprove alterations to the home made by owners, and then adopt specifications for roofs. So if you want to change specifications from a certain style or color of roof, typically that is something that the board can do. And certainly for hurricane protection specifications. So that is typically something that's done at a board meeting. I would say because those specifications would affect the property, then the board should notice that meeting with 14-day notice in advance, as opposed to a typical 48-hour notice. So mail or hand deliver a copy of that notice, or you can email it to owners who have consented to receiving notices by email, and then adopt written specifications. And then when the specifications are adopted by the board, make sure that you always provide a copy of the specs to the community, to the owner, so that they're aware of what the changes are. So that going forward, yes, you can install these types of roofs.
I guarantee you in the next 3 months, we're going to start getting tons of questions on hurricanes. Just down here, hurricane season in July.
Yes. And so, what boards should be doing, really condos and HOAs, start adopting specifications for hurricane protection, which would be, roofs, shutters, impact windows, really anything that would protect the home. Adopt the colors, the style, the material, and any other factor that the board deems relevant, so that when you do get a request from an owner to install hurricane shutters, regardless of whether you're in a condominium or an HOA, that you have basis upon which to review the request and then either approve it if the request complies with the specifications, or deny it. That is the basis for denial. If you don't have specs in place, then obviously it becomes more challenging to deny a request. So.
Wow, we got a lot of questions coming in on the chat line today. Dixon, with material alterations, what if something is altered but can still serve its original purpose? For example, pickleball, which we get a lot of questions on, and tennis extra lines. Is a vote still required?
Well, I guess it depends on what that material, quote unquote, material alteration is. I mean, if you're going to change the color of the pickleball court, from its original color to pink, I mean, it still serves its purpose, but I think the division would find that to be a material alteration. And so it might require membership approval, depending on what your documents provide.
Wow, just the color of the pickleball
Well,
For
yes, for condominiums, the division took this position years ago that, changing the color of the building or the exterior color of, any common element constitutes a material alteration, even if the paint color is at the end of its useful life. So,
let's go to Sylvette. Can an HOA paint your house a different color without, I'm sorry, okay, more questions coming, without homeowner's permission, even if the HOA is responsible for the paint exterior?
so the association is responsible for the exterior painting of all the buildings.
Can an HOA paint your house? So it must be HOA, paint your house of different color without the homeowner's permission.
I mean, that's a good
Even if,
question.
yeah,
It's not something that's addressed in the statute. That would be, document specific. I presume if the declaration gives the association the maintenance obligation, most likely gives the board the authority to choose the paint color. I don't know, or there could be a dollar threshold. That's something that the listener will have to confirm with the governing documents.
most of the time it's always back to the docs, isn't it?
Until the legislature decides to, regulate it in the statute, and then who
I always
knows?
wonder if people in the legislature live in a community association
That is a good question.
themselves.
They should poll the
Yeah, I know.
the representatives.
Again, back in the chat. Wow, a lot of questions coming in the chat. Is a management company required by law to have a physical office location, or can they offer on-site community appointments and not have an office for the homeowners to visit?
Uh, that's a good question. I honestly am not aware of any requirement in the law requires a property management firm to have a physical location. It's not unusual for the property manager sometimes to just work on site and have, work from an association office that's in the location of the community. But I don't know the specifics of requirement of physical location.
Okay. Let's move over to our text that came in. This is Greg in Orlando. If a board member was on the board last year and has a certification, he was just reelected. Does he have to take the class again?
Okay. And the listener didn't say if he's on the board of a condo or an HOA.
It doesn't.
Right. Okay. Well, the requirement to get to attend a board certification class within those 90 days, that is a requirement if you're a newly elected director. So if you're just new to the board, you have 90 days within which to complete your board certification class. If you were elected to the board prior to July 1st of last year, if you were elected to the board prior to July 1st of 2024, with condominiums, you have until June 30th of 2025 to complete the new board certification requirement, that 4-hour class. So for condos, you have until June 30th of this year, actually in a couple of months, to complete that. If this is for HOAs and you were elected to the board prior to July 1st of 2024, you have up to 4 years to complete that board certification requirement. That is the unofficial position of the division. It's not in the statute, and they haven't really published any additional guidelines, but that is my understanding as of now.
The board certifications are much longer now. How's that going?
Well, teaching the condominium certification class is a bit torture, as I'm sure it's a torturous
Yes.
for the board members to sit through 4 hours. We typically, when we teach, we try to split it with two attorneys. So each attorney
Hmm.
does 2 hours. The HOA board certification class, that's not required by law to be 4 hours long. So there's a bit of a misconception. That's not the requirement for HOAs. So I typically teach it between 2.5 hours. So that's not too bad.
No, that's what it kind of used to be, right?
Yes.
Rex and Kissimmee, can the person who does the reserve study or inspection also do the repairs? It seems like that's a conflict of interest.
Well, to be honest, I'm not aware of any reserve study specialist or engineer that's done these milestone inspection reports that they're actually also do the work. My recommendation, obviously, keep the contractor, the entity that's doing the repair, separate from the entity that does the milestone inspection or the reserve study.
What legal or regulatory measures can the association take to compel condominium unit owners who still have unprotected windows and doors over 35 years old and lacking any hurricane protection?
Well, that presumes that the owners are responsible for their windows, right? If windows are the maintenance responsibilities of the owners, then these maintenance covenants are just like any other covenant that the association can enforce. So if there's issues with the windows, if they're not properly maintained or whatnot, you could start with a demand letter. And then, there's potential remedies of, fining, suspension of use rights, and certainly, pre-suit mediation.
Okay. Go down here. Marvin and Lake Mary. Can you remove a present board member before the next election?
So couple of things. He says president and board directors. So let me just clarify two things. One is, remember, there's the board of directors, right, that are typically elected by the membership. And then there's officers. Officers are your president, vice president, treasurer, and secretary. And you could have, additional officers if permitted under the bylaws. The board of directors are the ones that elect the officers or appoint the officers, which means that if we're talking about removing a president from their president position, right, from their officer position, that can be done by the board, right? Because the officers serve at the pleasure of the director. So yes, the directors can remove the president from his president position and appoint someone else. But if we're talking about removal of this president, not only from the officer position, but from the board of directors, the only way that that can be done is through a recall process, which involves membership vote. Okay. And there is, this whole process of how to recall a board member, both in the condominium and the HOA statute. You kind of have to follow that. But in terms of removing a director from the board prior to the election, yes, but for condominiums, just be aware that if there's going to be if the owner's representative is going to legally challenge the recall attempt, the statute basically says that those recall petitions will not be reviewed by the division or court within 60 days of the election. So if you're too close to the election, might not a good idea to start this effort.
This is last question before we go to break, and we're also going to give you the schedule. um, for the month of May. Uh, Sharon and Castleberry, if you were delinquent on your assessments, can you still vote a board member out? And are you allowed to vote for the new member?
Okay, so I think Sharon is describing a recall process. Yes, even if the owner is delinquent on a monetary obligation to the association, I mean, you can still vote until the board formally suspends voting rights, right? The voting rights don't get stripped away just because an owner is delinquent. There has to be formal action, made by the board to suspend voting rights. If that was done, then no, the owner doesn't have the ability to vote. If the board hasn't suspended voting rights, then yes, the owner can still vote to remove a director through the recall process. Now, in terms of appointing new directors, well, that depends. If less than a majority of the directors are being removed, then that's something that typically the owners can appoint new directors in their place. If more than a majority of the board is getting recalled, then typically that's I'm sorry, I said it backwards. If more than a majority of the directors are being recalled, then that's typically when the members can appoint replacement.
Do you have your schedule in front of you for your classes coming
Yeah.
up? Good.
Let's see here. A lot is happening in April.
It always is with you all.
That is true. I feel like these scrolls are getting longer and longer. Let's see. Well, we'll start with April 25th, which is tomorrow. I'm teaching the condominium board certification class with Alan, and that's a webinar. It's going to be from 11 to 3. Alan is going to be doing the first 2 hours, so 11 to 1, and then I'm going to chime in at the latter part of the class, so 1 to 3. Then we have the HOA board certification class being taught by my colleague Peter, April 30th from 11 to 2, and that's going to be also a webinar. We have May 6th. So now we're going into May. I'm teaching a covenant enforceability class for HOAs and condominiums. That's also a webinar from 12 to 1. So I think there was a listener that asked about potential remedies. So this is when we're going to, dive in a little bit more detail about the remedies that the association has when trying to enforce a covenant. Then Michael Bender and Jeff Rembaum will be doing their association leadership episode 7 on May 7th from 12 to 1. May 14th, Alan is going to be attending the Orlando Condominium and HOA Expo. Those are always fun. And that's going to be at the Orange County Convention Center from 8 to 4:30. And Alan will be teaching 2 classes that day, live in person. The importance of updating the governing documents, and then the legal update. Okay, so this is the legal update that went into effect of changes in the law that took effect July 1st of 2024. And then I'm teaching on May 20th, another HOA board certification class from 11 to 2. That's going to be also a webinar. So we're teaching these board certification classes pretty regularly. At least a couple of times a month. So, check our calendar or on our website if you haven't done one of these. And then I'm actually going to teach a seminar live, so in person at the Seminole Garden Center. Let's see, what date is that? That's going to be on May 22nd. It's going to be a breakfast and learn. So, come in for, some bagels, donuts, coffee, and you can sit and listen and hear all about the importance of updating your governing documents. That's from 8:30 to 10. And then Danielle is teaching a class on assistance animals and pets. And that's always a hot topic. That's May 22nd, 11:30 to 12:30. Also a webinar.
I just want to get this. We're going to go to break. I just got this question in. It said, I love your show. Try to listen to every one of them. Because of your show, I have decided to run for my board. How do I go about getting certified through your practice? Can I do it through Zoom?
Yes, I mean, these webinars are via Zoom. So, go on our firm website. There's going to be a tab for our calendar. When you click on the certification class that you want to attend, there's going to be a link where you basically click on the link, and that's to sign up for the class. And then you will be sent a Zoom link that you will then use to attend the class virtually.
Great. We're going to go to break. Give people the phone number to call, which is actually good for, I think, all of your offices.
Yes, our main office number is 954-928-0680, and that is the main number. If you call, you will just be connected to the respective office with a switch of a button. So
beautiful. And it's www.kbrlegal.com. We're going to go to break right now. And we come back. We've got so many more of your questions. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
We are back. This is the last Thursday of the month. That means K. Bender Rembaum. They've been with us for 12 years. 12 years that we started off together, and gosh,
wow.
We have grown such a huge audience. And it's fun. We've had people, Kirsten, tell us that the women in the card room that play in the afternoon listen to the show. That's pretty amazing.
That is.
I love that. Let's go to Stan. Can the head of the HOA ARC approve or deny applications without an ARC meeting?
No. I mean, you would still need a vote typically of the majority of the ARC committee members if there is one. And typically that needs to be done at a duly noticed meeting so that no one single committee member has the ability to just approve or disapprove an application. And by the way, specifically for HOAs, just a reminder that, there was a law that went into effect July 1st regarding architectural changes that basically says that you now have, when you deny an ARC request, you now have to indicate on the denial basically the section of the covenant or the rule that you're using as your source of authority, and then what part of the proposed architectural change does not conform to the association standards. So, I know, for example, some ARC committees have, an application that owners typically fill out. And then at the bottom of the application, there's typically a, two check boxes, check approve or disapprove. And then the ARC member signs it and then sends it to the owner. Well, that no longer is going to be acceptable. You actually have to include the reasons of the denial.
In Orlando, we performed our 40 years 3 years ago, but now the county is demanding we do our 50-year now. These inspections are financially devastating. How are we supposed to do this?
Yeah, that's unusual that the county is requiring the 50-year recertification within 3 years of getting then the 40th, unless maybe the 40th wasn't timely, and that has happened. And so I think my best advice would be to whoever your engineer who did your 40-year inspection, consult with your engineer, see exactly what the city is requiring. If you did a 40-year not long ago, see if that would suffice for the 50-year. But that's something you definitely want to get your engineer involved in.
Joe wants to know, can the condo attorney recommend a new management company to the association? It seems like a conflict of interest.
Well, the association council should not be representing the management company. Okay, for sure, that's a problem. But I mean, there's nothing in the law that would prohibit, the association council to, provide, a few names of several, management companies for the board to vet, consider. I mean, that's just a referral. They're not necessarily recommending anyone. So, I mean, there's nothing wrong with that.
Okay. Again, in the chat line, can the condo board prohibit to unit owners to install items like antennas, Wi-Fi devices, and other electronics, items in the roof to protect the new TPO roof?
So typically the association, if we're talking about installations on common elements, then yes, typically the association can prevent these types of, installations or alterations to the common elements.
I got so many questions here from our listeners. I want to make sure I know that somebody wanted to know if there are new hurricane or if there's painting going on and you have to remove your hurricane shutters for the painting to be done. Who pays for the shutters to be put back up?
Well, there was a change in 718 that went into effect last year that says that if hurricane protection needs to be removed in order for the association to perform, maintenance repairs to the common elements, then the cost of the removal and reinstallation of the hurricane protection is on the association. And then there's another section in the statute just below that one that seems to contradict completely what the section above says. So hopefully that is going to be clarified in this new legislative session. But I think one could make a reasonable argument that if the hurricane shutters have to be removed for the association to do the necessary painting of the building, then the cost of the removal and reinstallation would be on the association. Now, if those, and that's presuming you can even get those shutters reinstalled, if they're still up to code. If they're not, then that's a whole other issue with those shutters. Yeah.
Sherry in Orlando, we had our elections and a new board member owns another property management company and he wants to change many vendors. Is that a conflict of interest?
Well, it would be a conflict of interest if that director is looking for the association to enter into some kind of contract with an entity in which that director has an interest. So, in the case where the director owns the management company, yeah, that is a conflict of interest. Now, the
Okay.
statute doesn't necessarily prohibit the association from entering into a contract that is a conflict of interest, but yes, the conflict of interest does have to be disclosed, and there are certain procedural requirements that the board has to follow in order to properly approve a contract that's a conflict of interest, including that 2/3 of the non-interested directors have to approve the contract. And then the contract does have to be disclosed to the membership at the next membership meeting, whether it's an annual or a special membership meeting. And then a majority of the owners that are present at the meeting can vote to cancel the contract. And if the membership votes to cancel the contract, then the association will have to terminate the contract, and then the association would not be responsible for any termination fees or penalties from terminating the contract early.
Sylvia in Orlando, we are an HOA. Can we see the delinquency reports?
So the delinquency report, I'm presuming it's basically the account ledgers of each home, of each parcel. Well,
Don't they have a name for that besides
the delinquency, right? I mean, listen, it is right. So the association has to maintain, an account ledger basically for each parcel, showing, the assessments being paid. So if an owner becomes delinquent, and that's reflected on the account ledger, I mean, it is an official record of the association. So yes, an owner can request access to the official records of the association and can inspect it. But certainly the association should just be publishing this.
Why would somebody want that, Kirsten?
I couldn't tell you. I mean, other than requesting their own account ledger to see, to
yes,
make sure
I can understand
everything there is accurate. Maybe personal reasons, want to make sure, especially if it's a director, if a director is delinquent,
right.
They would be deemed off the board. So who knows?
Armand in Orlando, he's an HOA. Should we have received a copy of all of our governing documents with the new statutes?
Yeah, so there was a change in the statute for Chapter 720 that required HOAs by October 1st of 2024 to provide physical or digital copies of the covenants and rules to the membership. So they could either mail copies, physical copies, or they do have the option of posting the covenants and rules on the association website. So that was a requirement that they needed to have complied with by October 1st of 2024. So long past.
Yeah, really. Nikki in Orlando, if a new director is appointed, is it not active until formally accepted and in the minutes?
No, typically when a director is elected or appointed, that's it. They're active. They hit the ground running.
Here's a kind of an interesting question. I don't know if it comes up very often. This is George in St. Pete, which is your area. We have 11 people running for the board for 9 spots. There was a tie for 9 and 10. What do we do with the tie?
Well, I mean, unless the bylaws provide for a system you can do many things. I mean, you can literally do, paper, rock, scissors. You can flip a coin. You can do, a number of things to see, you know, which one wins. And that's presuming that obviously one of the candidates doesn't want to voluntarily step down. If there's a process in the bylaws, or if it calls for a runoff election, you go with that. For condominiums, specifically, unless there is some other process in the bylaws, you have to have a runoff election within a certain time frame of the election. Essentially, within 21 to 30 days of your election meeting, you have to have a runoff election.
I think this is from one of Alan's relatives, Robert in Winter Park. Says, thank you so much for sharing so much for all your legal information with us each month. We really want you to know we appreciate your show. Can you have too many claims where we could lose our association insurance?
Well, I think that's everybody's fear, and I think it is possible. I think that is a conversation that I would recommend the board to have with their insurance agent. And especially, is putting the carrier on notice of a claim without actually filing claim does that go against the association? So yeah, I would have that conversation with the insurance agent.
Kenny in Orlando, he's a condo. He said, can a condo owner ask questions at the general board meetings?
Yes. I mean, unit owners have always had the right to speak at board meetings with regard to designated agenda items. And then the statute was changed last year, which now requires that at least 4 times a year, the board gives opportunity to owners to ask questions. So they can ask questions in addition to the items on the agenda, really as to the status of construction, repair projects, the status of expenditures, finances, and really any other issue affecting the condominium.
This is going to have to be our final question. The show goes by so fast. Kelly in Orlando is a condo. She said, we have no Kaufman language and we voted down the reserve. Do we still have to do SIR study?
Yes, I think the prevailing opinion of most practitioners is that regardless of whether or not you have Kaufman, the SIRS requirements do apply to condominium associations. So you have to get your reserve study done. Yep.
Well, this show always goes by so fast. Let's tell people again how they can reach your office and your website address. Someone just asked for your website address again.
Yes, so the website, it's kbrlegal.com, and the main number for the office, whether you want to reach Alan, since this is Alan's show, or myself, or really any other attorney at the firm, it's 954-928-0680.
I just want to tell we had so many people write in today, and we appreciate your questions. We try to get to as many as we can. We have another show coming up on
Next Tuesday.
Next week. Next
That's
Tuesday.
Mine.
Are you going to be doing Tuesday also?
Yes, I mean that is my typical time slot. Yeah,
that's correct. Well, we're so lucky to have you, Kirsten, and I'll see you on Tuesday. We'll be doing a show for our Tampa area. This is our Orlando show we do. And we will see you all. Thank you, Kirsten, so much. Great job as usual. That's going to be it for us today. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.